Yeah, so yeah, you can go ahead, Ashlin.
Thank you all for coming along at 5:30. I imagine a lot of you just want to go home for dinner. What we're going to do, I've got some slides, Alfredo, that we could possibly put up.
Yeah, I've made you also that you can share your screen.
Okay, yeah. It's made for a longer talk than what I'll give tonight. Tonight, we don't have a huge amount of time, so I'm just going to try and cover the basics of IP and then touch on a couple of issues which are very common problems that occur with business owners. And then we will open for questions. I'm sure some of you have some questions. You've probably, as business owners, encountered IP issues before. So you probably have a few questions. Let me share my screen now. There we go. And it throws me up there. I hate that. Right, so we'll go to the first thing. IP, intellectual property. So first, we need to define what is intellectual property. I also want to talk about why it's valuable and then sort of give you a rundown on the different types of IP. So IP is anything that you own that is a creation of the mind. It includes sort of unregistered rights, which are unregistered trademarks, copyright, trade secrets. The IP you also hold in things like your databases and customer client lists and things like that, as well as registered rights. So these are things that you have to apply for. So these include registered trademarks, patents, designs, plant variety rights. All IP rights are territorial, so they only apply in the country where you have those rights. They don't cross borders unless there is a treaty. For example, copyright, most countries have treaties around that, which means that one country will grant you the same rights as you get in your own country. The value in IP is really about the fact that you can create it the one time and receive revenue multiple times. So you don't need to recreate the thing every time in order to make money. If you're producing a product, you need to reproduce a product to make money. With IP, you can license and someone else can produce a product and you'll receive a royalty every time that product is produced. If you're a musician, for example, you just produce a song once and then you receive ongoing royalties from that work. It's like other assets, like physical assets. IP is an intangible asset and you can use it in much the same way you can with any physical asset. You can rent it out or license it. You can sell it. You can use it to attract investment, act as security, and so on. If you look at a lot of the businesses around the world, particularly now, a lot of their value is tied up in their IP. Companies like Microsoft and Apple and Google and so on, almost all their value is tied up in their IP, something like 90%. So it isn't a really important part of business and something we all sort of need to be paying attention, even small business owners. So I'll just go back to the top, and because we won't cover everything in detail, but I just sort of want to run through the different types of IP. So we have different types for different purposes. A trademark is something that protects your brand. That's your business name or your logo or your branding. Patents are for inventions. If you invent something, a brand new widget, you can get a patent for that, and that's what a patent's for. Design registrations for things that are of a novel appearance. So for example, you've probably got a coffee mug in front of you or something like that. If that's a particularly novel design and you want to protect that, then a design registration is how you would do so. Copyright, you're probably familiar with. That's something that covers the expression of idea, artistic works. So music, movies, books, written material. Plant variety rights, if you breed new plant varieties, then plant variety rights can give you ownership of those rights. Trade secrets are unregistered rights. They're not a formal intellectual property right. They're only protected in terms of how you are able to keep it confidential. So basically contract law. If your employees are contracted to keep your information confidential, and you can keep some particular trade secret, say like the KFC secret recipe, if you can keep that secret, you can retain ownership of it effectively, even if you don't have any formal IP rights. So it can be really useful, and with all the software as a service companies coming along, they mostly rely on their trade secrets to give them an edge over their competitors. So we'll just touch on, there's really sort of two types of IP I want to cover tonight, because these are the sort of most common issues that we encounter. The first is going to be trademark. So every company has a brand, or at least a name for their company, and protecting that brand is really important. You don't want copycats, you don't want counterfeiters, you don't want to end up in disputes with other people using your brand. So trademarks are a really useful way of helping sort of alleviate those issues. A really important part of business as well. So a trademark is anything that you can be used to distinguish your goods and services from those of others. It's not just a logo or a word. You can protect sounds, stylizations, smells, even color. So Cadbury, for example, have a particular purple for chocolate. So you can't produce chocolate using that same color purple. There are registered and unregistered trademark rights. Just by using a brand in business, you gain unregistered trademark rights. They are, however, limited by your reputation. So, for example, if you've got chocolate, you produce chocolate, but you don't have a registered trademark for your brand, then you want to expand into confectionery, you may find it difficult to stop someone else using your brand if they want to do confectionery before you. Registered trademark rights are much easier to enforce. If you have it and someone is copying your brand, using your brand for the same or similar goods or services, then they infringe and you can stop them. There's some examples. I can send these slides around afterwards, actually, Alfredo, if you want some. So don't try and take notes or anything. And yeah, I'm always available to have a chat if you want to give me a call and we can discuss any of the issues in the talk. So we're all well aware of some really well-known trademarks, Coke, Apple, iPhone. These are incredibly valuable brands, and they're all protected by registered trademarks. Those registered trademarks are really important. For a small business owner, there's a lot of value in a registered trademark. It gives you, helps you with settling domain name disputes, which for a startup often comes up. You know, you're trying to find a domain name that no one else has already got. And that can be difficult. Once you've got one you like, you don't want other people using that same domain name. So in certain circumstances, you can stop them using their domain if they're infringing your trademark. So one of the, probably the big thing I want to cover tonight really is a common mistake business owners make is using descriptive trademarks. So they'll come up with, say, Nelson Auto Services or something like that. They're trying to describe what they do in their brand, and they call themselves that, they brand everything, and it causes a bunch of issues. The first being you can't register a trademark for something that is descriptive. And the reason for that is that the government doesn't want a trademark owner to monopolize the use of a term that people in that industry might need to use. So Nelson Auto Services, for example, if you are another mechanic in Nelson, you should be able to call yourself a Nelson Auto Service. So there's always a balance in IP between the rights of the owner and the rights of consumers, society, government, and so on. It is very tempting to use a descriptive trademark when you start out in business. It sort of you feel that, well, okay, it tells consumers what I do. And also when I have a domain name, if it describes what I do, then when people search for that, they will find me. However, there's a couple of problems with that. While it helps at the start with domain names, for example, once you get established, you then can't distinguish yourself from everyone else. So even 10 years down the track, if people are searching for Nelson Auto Services, they will find you, but they'll also find every other Nelson Auto Service out there. Whereas if you have something that is distinctive, say 0 for a mechanic, then once you've established that reputation, people will search for that brand and they will find you and hopefully no one else. So while it's tempting to do something descriptive, it's really not a good idea. So this slide here sort of talks about what makes good trademark. It needs to be distinctive, it needs to set yourself apart from other competitors. It can't just be something generic or descriptive. It's also sometimes good if you can come up with a brand that is suggestive or alludes to the goods or services that you're creating. So I'll provide an example there, like Sleepyhead, for example, for beds. It's not describing what they do, it's not saying we're a bed seller, but you kind of get the implication just by reading the word. So also a list of things you can't register as a trademark down there. Oh, you can't see my mouse again, so. Right. Actually, we'll stop there. Just, does anyone have any questions at that point? No. So when you're coming up with a trademark, and the business owners and the people you talk to in your tab boards, that's really useful information. What I get people to do is just brainstorm. So spend the time when you're coming up with a new brand, spend the time thinking of any old word, anything you can think of, just write them all down and then work through them and sort of filter out the ones that won't work, the ones you don't like, the ones you can't register as a trademark, until you come down to a short list and then make a call on that. You also need to check whether the trademark or your brand is available to use. So the flip side of owning a trademark is that with branding, you may infringe someone else's trademark. So knowing that, it is really important, because if you go ahead and say, for example, you've got a cafe, you produce signage, you produce branding on your cups and merchandise and so on, you then go and start operating, and then you get a letter saying, hey, look, you're infringing our trademark. We already own the rights to that. You need to stop. Then you have to rebrand. You have to produce new signage, and it's very expensive. A little bit of work at the start before you go down that road can save you a lot of money. You can file your own trademarks. You don't need to use a patent attorney to do that. There's obviously just the risk that you make a mistake and you end up not covering your trademark. A few warnings, which are some common mistakes people make. They think that by registering their company that protects their trademark, and that's not the case at all. So different issues. It's important to file that application before you commit to your brand, so that you know that whether or not you can obtain the trademark for that brand. Also, don't talk to competitors about your trademark before you've applied. It is rare, but you don't want them going and making that application before you. Changing the spelling of something doesn't avoid infringement. People hear brands as well as see them. You hear a brand on the radio, so just changing the spelling, if it's said the same, is not going to avoid infringement. And there's a few myths. There's a percentage myth, which is very common for all IP. There's this idea that if you change something by a particular percentage that you won't infringe, but there is no such rule at all. You also can't trademark your idea, book, invention, or movie. That's what the other types of IP are for. Trademarks don't last forever. You do have to renew them at 10 years. And if you don't use your trademark, it is vulnerable to being cancelled. So you need to make sure that you can't sort of cyber squat on a trademark. The difference between unregistered and registered trademarks, so you'll see some brands using the TM. That indicates that they're using that brand as a trademark, but it's not registered. If it is a registered trademark, it should have an R in the circle. And you can, as I said before, you can register more than just words and logos. So we'll move on to patents. Any questions at that point? Stephen?
Are you talking, Ashlin, specifically about New Zealand here? And what implications does having a New Zealand registered trademark have on using your product or service internationally and wanting to apply for registration of the trademark in other countries?
Yeah, so trademarks are territorial. So the New Zealand trademark has no effect in the US, for example, and vice versa. So if you want your trademark registered overseas, you have to make it an application in those countries that you want protection. There is an international trademark application. You still need to designate which countries you want covered by it, but it is a very cost-effective way of getting coverage in a whole bunch of countries.
Thanks, Ashlin.
All right, we might actually get a fair way through this. Let's keep going. So patents are for inventions. That's sort of what we mostly do is work on patents. Patents give you a short-term monopoly, 20 years normally, to stop others from making, using, or selling the invention as claimed in the patent. An invention is something that is novel and inventive. So not something that is novel is new to the world, hasn't been done before. Inventive means that it's not an obvious combination of known things. Say, for example, you have a car and you want to, you paint it pink with lime green stripes. You may be the first person to ever do that. It may be novel, but it's not inventive because you're using known processes. You're painting a car in a different color. The idea with a patent is it is an exchange between the public and the inventor. The inventor gives their knowledge to the public, and in exchange, the public gives the inventor that 20-year monopoly on the right to stop others from making, using, or selling it. So part of the process of patent application is to describe the invention in detail so that the public can reproduce the invention by reading that document. So once a patent is expired, whether that's at the end of the 20-year term or because it's lapsed for whatever reason, that information is in the public domain and you can use it however you want. Patents, like trademarks, are also territorial. So, you know, a New Zealand patent only has effect in New Zealand. US patent only has effect in the US. So patents can be really valuable if they're covering a product that has a lot of value, then that patent will also attract a lot of value. So for example, Samsung and Apple had a big dispute a few years ago now. And there were, millions of dollars worth of, well, actually it was like 1.5 billion, I think, in the end. However, on the judgment in terms of Apple suing Samsung, that got scaled back, of course, but yeah, huge value if the product is valuable. Excuse me. Patents can often, people sort of look at them and say, oh, well, how much value is a patent? How valuable is a patent? And it really comes back to how valuable the product is. If lots of people using the product, then the patent will be very valuable. If not many people are, then no, maybe the patent doesn't have a lot of value. But you can use it as an asset, much like any other. You hear about patent licensing. It's also good as a marketing tool. If you've got a new product, you can put your patented mark on it so that people know that it has a sort of exclusivity to it, that you're the only one producing it. Investors are very keen on seeing patents for people who approach them for investment. If they've got any sort of novel technology, they want to know that you have a patent, or at least that you've considered it and discounted it for whatever reason. Cool. So there's a few requirements to obtain patents. We talked about novelty and inventive step. Some countries also have specific exclusions as to different types of technology that they won't accept patents for. In New Zealand, we have it was introduced a few years ago, an exclusion to software as such. It doesn't mean that all software is not patentable. It can be defined as a method, and you may be able to get a patent for it. But other countries, for example, India also have a sort of software exclusion. Some have exclusions for medical treatments and things like that. But invention can be, doesn't need just to be a machine, products, processes, chemical compositions. So to avoid a lot of the mistakes we see with when people come to us for a patent, we want to make sure that our clients do their research, and not just research into the market, research into the technology, and also whether there's already existing patents in that field. A lot of times people will come to us and say, look, I've got a new idea, and they'll say, well, look, I haven't seen it in Mitre 10 or on the internet, but they've done sort of 10 minutes searching it. It's not thorough. And then we do a search for them and we find their invention. So as much as it's hard work, it's really important to do that research. The market research is really key part as well. I mean, you're all business owners, so you know this stuff anyway, but there's no point spending all that money and time and effort on a patent if there's no market for the product. You need to work out, your margins, how much volume you think you can sell, make sure it's worthwhile. So there's a couple of warnings to make. As soon as you publicize details of your invention, the novelty in it is destroyed and you can't get a patent for it. There are grace periods in some countries, but it's best to keep it secret up until you've filed a patent. Once you file a patent application, then you can disclose the invention without jeopardizing that patent. So it's also important that you don't commercialize the invention. So even if it's secret, so you've got a colleague and you think, hey, look, we've got a new invention. If we collaborate, I'll sell you the invention for this much, and once it's available, that can also destroy the novelty in the invention as well. So it's something you need to avoid. I won't run through this, but basically, it's not really worth doing your own patent application. It probably will not have any value. The whole point in the patent application, the patent, is to have value to either an investor, someone buying it, or someone who you're suing for infringement. And writing it yourself, you're unlikely to achieve those goals. So I've got a few cartoons here. These are sort of common problems that we have with inventors. We'll go down here. So over-engineering things. Engineers love doing this, making something more complex than what's really needed. And of course, telling people about the idea before they've filed a patent application. Don't talk to people in the pub about it. It's important to work out whether your invention is new or not. There's no point going down the track if what you've got isn't new. Sometimes you invent something but you haven't really worked out, well, why has no one done this before? Maybe there's a reason. Maybe it doesn't work. And another key part, which is really a commercial aspect, but it's important that there's a market need for the product, for the invention. No point going down that road if no one's going to buy it. Sooner or later, an invention will come out. So unless you've got a business model where you can keep trade secrets, say software as a service, and even then people can kind of work out what you're doing and replicate it. So yeah, trying to keep it secret is not always the best option. And just because you have a patent and an invention does not mean that it's worth billions. You know, the value of it comes down to every specific circumstance. So there's a few myths around patents that we hear. So if you have a patent, it does not give you the right to produce your invention. Every invention is made up of a bunch of other things, a bunch of components, and any one of those may have a patent on it. So you may infringe someone else's patent even though you have a patent for your invention. We also have the common 20% infringement myth. There's no percentage measure. It comes down to what is claimed in the patent claims. Once you have a patent application, you still need to police it yourself. There's no government police that watches out for infringement. You need to be aware of what your competitor is doing and work out whether anyone else is infringing or not. There are no worldwide patents. Patents are territorial. Now, you don't need a revolutionary idea either. Most inventions are incremental, that they are built upon existing technology. And that advancement of technology is what we sort of want to encourage with patents. We want to reward inventors for moving technology forward. I'll stop there and just, have any questions about patents?
Stephen, yep.
The 20-year life or 25 for pharma of patents, Ashlin, is that an internationally accepted time limit, or is that varying by territory?
I think that's universal. I'm not aware of any country doing other than 20 years. There are variations for pharmaceuticals because the regulatory timeline to get approval is so long, so that's sort of compensating those companies. But yeah, I don't think there's any country that does anything other than 20 years.
Okay, thank you. And would patents apply to recipes and formulas of food or drink products?
Yeah, absolutely. If they are novel and inventive. If you're mixing components, say recipe, the components are known components, sugar, flour, eggs, milk, and you mix them together. If you create something new, it's possibly not inventive though, because all those components, their behavior and what they do together is known. However, if you mix together, I know, citric acid and bubblegum and you create a new marshmallow, then maybe.
So for example, the Coca-Cola formula that's very protected and held secret, is there a patent on that, or does that fall under the category of trade secret?
That is a trade secret. So that formulation's been around for a long time. So they decided a long time ago that they probably couldn't get a patent for it. And so they kept it as trade secret.
Okay.
Any other questions from anyone? I don't see you all because the slides are on, but if you want to just unmute and make the question. So maybe you can go ahead, Ashlin.
Yeah, okay. So registered designs in the States, they're called design patents.
Yeah, hey, sorry, Ashlin. Yeah, Peter Gibson had a question.
Yep. Look, Ashlin, just a query. You talked about prior art, and so you're in a situation where something might have, the same sort of process might have been developed and designed 25 years ago, never been commercialized, and has obviously lapsed, it hasn't been renewed, and you come up with a, say, a variation of it in the latest technology. Is that capable of being patented?
Yeah, if that development that you've made is novel and inventive, then yes, yeah. So as we sort of talked about it, all inventions are built on prior art, prior inventions. So as long as there's an improvement there and what you've got is novel and inventive, yeah.
And the other reason was, as I understand it, trade secrets is probably like when you patent something, you're actually basically describing to everybody what you've invented, whereas a trade secret is a trade secret and nobody, unless they steal it or find out in some way, are privy to what that actually is. So as long as you can protect it, you've actually got more of a start than somebody else looking at your invention and coming up with a, you know, an improved version of it a few years later, as in terms of development.
Yeah, exactly. I mean, you can reverse engineer most things. If you can't reverse engineer it and you've got some secret sauce behind your software, then a trade secret does actually make sense. You don't want to tell the world about how you're doing it. So it makes sense then to not patent it, because that requires you to publish how it works.
All right, thank you.
Yeah, well, so we'll move on to designs. I'm not sure if any of you have physical products, but registered designs protect the way something looks, not what it does, but the way it looks. So it's a sort of a form of copyright, halfway between copyright and patents, really, in that it's only protecting how something looks and not it functions, but you still need to apply for it, and it still needs to be novel. The design itself needs to be novel. So you can't register a design for something it's already out there. So here's probably an IP right where the time, the monopoly that they give you varies a lot. So some countries like Australia and China, for example, only give you 10 years, whereas Europe gives you 25 years. So, and that covers all of the EU minus UK now. But yeah, so there's a big variation here, and whether that's valuable or not is up to sort of that market research. In Australia, though, one thing to note is that you don't have copyright in a 3D design unless you've applied for a design registration. There's a peculiar law there. So if you don't apply for a design for a product in Australia, then yeah, there's not much you can do about it. Other countries do give you copyright. Designs, much like patents, they're an asset, an intangible asset you can use to attract investment. You can sell, license them, and do whatever you need with them. So the Apple and Samsung case was the big one from, well, it's probably 10 years ago now, but they were awarded $500 million for design infringement. And that was Samsung copying the shape of the iPhone. That's sort of still in dispute, but it shows the potential value of designs. If you have something that is so popular and copied by your competitors, those designs can have tremendous value. So to get a design, the primary thing is it must be new, and you always need to be aware that it covers the form of the product, not its function. So it needs to be visually aesthetic in some way, and a competitor needs to be able to sort of reproduce a product in a way that doesn't have the same visual appearance. So there's sort of
Just one question, Ashley. Because architects create very special buildings. Are buildings something that you can register or something, or not? Or it has to be just other type of things?
Yeah, so building architectural designs are covered by copyright. You probably can register design for a particular type of building. But generally, architects rely on copyright to protect their designs, yeah.
Okay, thank you.
And there'd be plenty of cases where architects have had their designs copied by competitors and then sued them for infringement.
Okay.
It's best to talk to a patent attorney about registering your design. It's very tempting to do it yourself and just file some photos of your design, but it is very limiting if you do it that way. There are ways to broaden the scope of your design so you have greater coverage and minimize the chance that an infringer gets away by changing minor features, well, unimportant features. So like with patents, don't sell or disclose your idea before you apply. You need to do that first. You need to apply first. When you're applying for design, you need to think about what is so distinctive about it. Which part of your product has that particularly commercially valuable, visually aesthetic piece. So, oh yeah, any questions on designs? I was thinking we wouldn't get all the way through this, but I think we're gonna, I think we might manage. So yeah, we'll move on to copyright. So copyright's a huge topic. We're really just gonna scratch the surface here. But copyright gives you the right to stop someone else from copying your creative work. That could be a book, it could be music, plays, and so on. It's important to note that you can only stop someone from copying your work. You can't stop them if they've come up with the work themselves. So if it's an original work that they've created and it happens to be similar or to your creation, then that's not copyright. So you need to show how that they're copied. You also can't copy something, if you copy someone else's work, you can't have copyright in that work. It's only for the original work that the copyright resides. Copyright's automatic in New Zealand and most countries, and there are treaties in place that, reciprocal treaties, so that the copyright here, say for example in the US, will grant you copyright even though you're a New Zealand citizen producing it in New Zealand. Generally, the author owns the copyright unless there's a contract otherwise. So if you're the commissioning party, if you've paid someone to produce copyright work, then you would normally own it unless there's a contract otherwise. So it is really important if you're paying for web designers, people like that, that in your contracts with them, you specify that you own the copyright in their work. A lot of designers will try and claim copyright for themselves, and that may be fine if that's what you agree on, but it pays to check who will own the copyright when you're paying someone else to do work for you. Copyright only protects the expression of an idea, not the idea itself. So it's only covering say for example, Harry Potter. The Harry Potter books are covered by copyright, but the idea of a boy wizard, that is not covered by copyright. You can write your own story about a boy wizard, that's fine. So copyright terms vary depending on the type of work, and so for example, your books, I think this also varies by country as well, and there are pushes from various countries to change the terms. But in New Zealand, books, musical and artistic works, 50 years past death of the author. So it is a long time, and the benefit from copyright extends for quite a long time, and the families are the ones that benefit, or normally the record company. For film, it's 50 years from the end of the year the film came out. We also have industrial copyright in New Zealand. That means if you reproduce something in 3D form, so you and you've done more than 50 reproductions, then you have copyright in that, and it runs for 16 years from the 51st reproduction. So even without a design registration, you still may have intellectual property in something that you've reproduced. Yeah, there's lots of exceptions to copyright infringement. We won't get into those here, but for example, if you're reporting in the news, you are not infringing copyright if you quote someone else. We talked about that. Copyright is obviously very valuable. Musicians rely on it to receive income, filmmakers and so on, authors. Can be sold, licensed, traded, can be used to attract investment. The big copyright myth is that percentage myth we talked about before. People feel that, hey, look, I've got Harry Potter. If I just change the book, I'll cut out the last 15 paragraphs and maybe I won't infringe copyright. Doesn't work like that. It's still infringing. Also, just acknowledging the artist is not an exception to copyright infringement. So you can't copy something off the internet and then say, hey, look, here's where it came from and avoid infringement. You need to get permission from them. Also, just because there's no copyright notice, it doesn't mean it's not covered by copyright. So anything you produce on your website and in your written material, if you put the C in the circle and the year that it's produced, it's just a notification to others that you're claiming copyright in that work. Just because it's on the internet doesn't mean you can use it. You need to ask permission, or some websites, of course, have copyright license terms that allow you to copy things under certain restrictions, or maybe free. And even for private use, you're still infringing copyright. Doesn't need to be commercial. So if you are going to copy something, seek advice from a lawyer who's specialized in copyright, and yeah, ask that advice. If you are creating something, then you are creating the original work. You own copyright in that. You can't be copyright infringement if you created it. It's only if you copy someone else's. Any questions on copyright?
Yep, I've got a question, Ashlin. It's we make a type of piping board. It's like a manifold of a particular type. It's unique, and at the end of the day, I've ended up putting a label on the product saying it's copyright, and that's just to try and provide some resistance to copying the thing. And I don't know how effective that's, if that actually could stand up.
How long have you been producing the product?
In some cases, say 5 years.
Yeah, so you may be covered by industrial copyrights. It may not be a sort of false marking, but yeah, that's sort of, you get into sort of specific advice. You need to talk to a copyright lawyer about that.
Okay. But otherwise, anything else we publish ourselves, and we put copyright on that, that's anything we print or produce in that way is still copyright, stands out in its own right. Hey. That's
right, yeah. And so someone copying that needs your permission to do so.
Yeah, yeah.
I mean, policing copyright is a difficult thing. You know, you can't chase everyone. If you're a musician, then you rely on there's collective organizations that go around and sort of sue people for infringing copyright on your behalf.
Mm.
But as a small business owner, it's often not feasible to sue someone, but that doesn't stop you from sending them warnings, getting your lawyer to send a warning, and that may be enough to stop them from continuing to copy.
Yeah.
Any other questions from anyone?
We'll just skim over PVRs, plant variety rights. If you're in the horticulture industry, it's probably an important part of your business, but a plant variety right particular breed, variety of plant, as you can imagine. At the moment, includes fungus, and the rules going through Parliament at the moment should add algae to the list of plants that you can protect with PBR, but bacteria are not going to be added. Did I talk about? So zestberry and the gold kiwi fruit is probably something you're aware of that's covered by PBRs, and they've made a lot of money out of that PBR. It can be used like any other form of IP. You can sell them, you can license it. So the licensing of plant varieties is big business. Apples, New Zealand is quite big in this front because we have quite a big horticulture industry and developing apples, kiwi fruit and so on. And you can apply overseas for PBRs as well. And so you can breed a new variety here, apply for a PBR in the States, and then license for growers there to reproduce that plant variety. What are we at 619? The PBR just needs to be new, needs to be distinct, uniform, stable, and has to be an acceptable name. So you can't give a PBR the name of a trademark, a registered trademark, and vice versa. You can't register a trademark for a plant variety right name. I will just touch on trade secrets. We mentioned before Coca-Cola, and KFC also kept their recipe as a trade secret. Pretty sure people know what it is now, but for a long time they relied on that trade secret. So your trade secrets include any confidential information that you have that provides commercial advantage. So your customer databases, AI algorithms, your software as a service backend, things like that. It does rely on you keeping it secret. So you need to make sure that your employees in their employment contracts, of course, have confidentiality clauses to make sure that if they do go and tell your competitors about your secret source, that you can sue them. Good record keeping is really important with trade secrets to show that you did have ownership of that information, so that if it does pop up in your competitors' products, then you can say, hello, we own that, we can trace it came from our employee or a breach of IT systems or so on. So pretty good timing, I think. Do we have any questions on PBRs or trade secrets? So with IP, yeah, hopefully I've really just covered the sort of really high level stuff. If you have any questions about anything specific, get my contact details off Alfredo. Happy to have a chat about anything.
Just one question before you go, is that some companies go and buy opposition companies, close them down. Once they do that, does the companies they closed or got rid of so they can be dominant in the market, if somebody else has knowledge of, the product which was produced or the information or the software or whatever, what is the situation here?
That's a good question. We're still guided by those contracts. So I presume if there's something in the contract that actually a lot of the contracts, the confidentiality will survive the contract. So even though the contract might be null and void because the company's closed down, that confidentiality obligation would probably still be held by the employer. So they still couldn't go and take that to someone else without getting permission from whoever should own that information. So you're probably best to talk to a lawyer about that and sort of look at looking at the contracts of employees and the company and what happens when the company goes bankrupt or ceases, and what happens to the information. It's all guided by contract and contract law.
Any other questions, Stephen? Yeah.
General one, Ashlin. Are you ever aware of public good over ruling any copyright rights? For example, seatbelts, airbags, COVID-19 vaccines, where the public good is so overwhelming. Do the companies with those inventions still get the full protection under intellectual property law if they've followed all the procedures appropriately?
Yeah, so the governments would need to create an exception. So most patent law includes a like a national security exception, or which probably would fall under what you're talking about there. They could apply that national security and they could get a license to that IP. They would still probably need to pay for it, but there would be there are also what's called compulsory licenses. So if a market has not been supplied with an invention, for example, for whatever period of time, then you can apply to the owner for a for a compulsory license. That means the owner has to give you a license to produce that product because they haven't met the market need for it. The COVID vaccines, there are movement from various governments around the world to, I don't know if nullify is the right word, but basically invoke those national security laws and say that the vaccine, the IP behind the vaccine technology is available to whoever wants it for a license. So in other words, the patent owners can't choose who is going to be able to produce the vaccine. Right. I'm not aware of, I don't know what the status of that is at the moment. It's been talked about for the last year, but I'm not sure what status it is at the moment.
Okay, so there can be exceptions to the rules where circumstances dictate. Yeah.
I mean, the government can say whatever they want. So
yeah.
Ultimately, they produce a law that produce an exception. Yeah.
I think India, for example, producing a lot of medicine, and some other countries which have capacity of producing medicines, and they overrule some of those bigger companies' patent if it is for the benefit, the good of the nation or the nations which are deprived third world countries, for example.
Yes, Stephen, go ahead.
Different tack, Ashlin. How far can you rely on the protections afforded by other countries to your patents or inventions or whatever? I mean, the classic well-publicized issue around China copying products, and yet those companies probably have got patents registered in the Chinese patent office. So how effective is it in other jurisdictions? Can it be relied upon?
Yeah, I mean, the laws are much the same everywhere, including China. They have fairly strict laws. But China's possibly unique in a sense that they have such enormous manufacturing capability that even if you stop one producer, you sue them, shut them down, another one pops up down the road, and they're just very efficient at producing, manufacturing. So counterfeiting is, a massive problem there. It's really probably comes down to money, how much money you want to throw at it and whether it's worthwhile. And another problem with the Chinese counterfeiters is that it's often not worth the finance. It's not worth the money to sue a company because you know that you're only going to receive less than what it costs you to sort of pursue them. And so you sort of need to be pragmatic about who you pursue and how. And the cost of suing for patent infringement, for example, it is expensive. And even in like the States or Europe, you're looking at $1 million plus to sue someone for patent infringement. So it needs to be worthwhile. And so chasing the smaller guys is often not worthwhile. However, most disputes don't make it to court. If you send a cease and desist letter with the patent, you can often get traction and went into negotiations with them or a license deal or something like that. Very few patents get litigated. It's only when both sides think that they can win that you end up with a dispute. So it's sort of, yeah, it's difficult, but the likelihood you run into that issue is very small.
All right, we have 2 minutes to go. Maybe could you stop sharing and then we see everyone, Ashlin?
All right, yeah.
Is there any final question from anyone?
Probably just one. Sorry, I was going to just ask a question.
Yeah.
One of my suppliers have a certain shape and a copyright from Italy, and somebody locally here copied that shape, the face of a lady, but made it look the other way. At the time, he was a small player, and he was advised, and we did everything right, but we didn't pursue it because he was just insignificant at the time. Now that company got sold to a much bigger company. Is it worthwhile pursuing if this new bigger company is now going to use that logo? Even so, he used it for 5 or 6 years, and he has been notified at the time that he is using a variation of the shape. So if you look at the lady, he's just almost a mirror shape, and instead of looking up, looking down.
Is this a trademark? Or is this a product shape?
So the product is, exactly, it's olive oil, and it's a company since 1901, and the company here in New Zealand just copied that logo and used it for the last few years. But earlier in the piece, we have advised them through a patent solicitor that they have infringed, and they have, and this has been copyright. And now he sold the company about a year ago to a much bigger company in New Zealand. So if they continue to use that, it is, the fact that he illegally used that patent, does it make it any different for pursuing the new owners of that, brand?
No. So whoever owns the trademark, it will be a trademark for that logo. Whoever owns that can sue the new company for trademark infringement. Yeah, so the trademark, if it's registered, if it's alive, yeah, they can sue them for that. So just because it's transferred or it's got some minor detail change, probably won't avoid infringement.
Okay, thanks.
Thanks. Hans, you wanted to say something and then we finish?
Yes, I just wanted to clarify. We sell other people's software, and we also design our own software, and we have a group of developers. And I just want to clarify, I'm pretty sure in our employment agreements for our staff that we stipulate any work they conduct while working at CADPro, all the code is copyright owned by CADPro, by my company. Is that enough protection for me as the business owner to make it very clear that the code that my developers are generating is copyright owner of CADPro?
Yeah, so in your employment contracts, you'll have that copyright clause.
Yeah.
Or do you mean with your customers?
No, with my staff.
With your staff, yeah.
And the customer one you mentioned earlier has come up. We've had that a couple of times where we've said, well, we're developing the code for you, Mr. Customer. We'll own copyright. And then they go, oh, no, we feel uncomfortable about that. We're paying for your service. We would like to own your copyright. And then we go, yeah, okay. Otherwise, we might not get any work.
Right.
So that is a very interesting negotiation that takes place. I've been on both sides of that fence. But yeah, I think there's generally a lot of software is a really tricky one. and I probably need to talk to you independently.
Yeah, or talk to a copyright lawyer. Yeah, you can have sort of a license arrangement. So you would give them an exclusive license, for example, to copyright, but only in that particular embodiment, website, whatever it is. But you would be able to reuse for whatever other purpose. I mean, you can negotiate and come up with some arrangement. But yeah, talk to your lawyers about that. So you're with your employees. Yeah, make sure you've got a copyright clause in there and a confidentiality clause. Then yeah, that's what we can do.
Thank you.
All right. Well, thank you, everyone. And thank you, Ashlin, for presenting today. I think it was really interesting. And well, yeah, if anyone needs, so we will share the video if that's fine, Ashlin. And if you send some slides, it would be great. And if anybody needs to contact Ashlin just to have a chat, yeah, just let me know.
Great presentation, Ashlin. Thank you.
Thank you.
Have a good evening. I will stop recording now.